Hello and welcome to our webinar. Today we're going to be talking about the new Florida law, dubbed the Mini TCPA law. And joining me, I'm pleased to have Eric Troutman of Squire, Patton, Boggs. Eric is nationally recognized as one of the top TCPA compliance experts. Eric, tell us a little more about yourself, if there's anybody out there that hasn't heard about your bio.
Sure, I'm the Czar of the TCPA. That's all you need to know. I'm the guy that runs TCPAWorld.com, see right there. I've been doing nothing but TCPA defense for 10, 12 years now. I've litigated thousands of cases and I've been lead counsel in over 250 nationwide class actions. I serve as National Strategic Counsel for companies that are big and small and provide compliance assistance as well.
Great. All right, well, thank you. And just kind of giving some context here. Back in April, we had the Supreme Court ruling on Facebook versus Do Good. And that came out, and we were waiting to see how the state legislatures would respond. And then Florida comes out with this law, which we saw each other back at the Industry Impact Summit put on by LeadsCon and Leads Council back in June in Kansas City, and then it wasn't yet law, but now it's been signed by the governor. So tell us a little more about what this law means.
Yeah, so it's it's very interesting because the bill was passed back in April, and we did a thing on it on TCPAWorld, like nobody else was talking about it, and then we covered it, and all of a sudden it started getting all this press, and everyone was talking about it. So it's a bill. It was signed by the governor June 30th and became effective July 1. So surprise, it does two main things. Okay, on the first hand, it amends one section of the existing Florida solicitation law to add a private right of action and to make it illegal to utilize an autodialer without express written consent for marketing purposes. And the definition of autodialer here is different than the TCPA, and we'll talk about that in a second. On the other hand, there's a completely different section of the Florida telemarketing law, not the solicitation law, but the telemarketing law that was also edited. And under this new section, if you are an individual who is making telephone solicitation calls, I know it's in the marketing section, but it still references solicitation calls, you are going to need to not make calls after 8 p.m. and you're going to have to limit your number of attempts to this individual to 3 per 24 hours, even if you have consent. Really interesting limitation.
Okay, and so tell us, you mentioned there's a different definition in terms of what an autodialer is, what an ATDS is. What is the definition that the Florida bill involves?
Yeah, so ATDS is of course TCPA lingo. It means automatic telephone dialing system as defined in 227A1 of the TCPA, which was interpreted by the Facebook decision by the Supreme Court. This is totally different, okay? It's not an ATDS, it's just an autodialer. And an autodialer in Florida does not have a specific definition, but as it reads in the statute itself, an autodialer is anything that calls automatically, that is to say, uses a computer to dial numbers, or, this is really interesting, uses a computer to sequence the phone numbers to be dialed. So even click-to-dial systems under this definition would still trigger an autodialer application in Florida if the computer is deciding which number you should click next. And we can think of systems where, for instance, a human being is selecting the sequence of numbers to be dialed, and that would not be an autodialer. We can think of systems where, for instance, a consumer or an agent is pulling up a system of record, finding a number they want to click on, clicking on that number. That would not be an autodialer. But a system that is queuing up phone numbers merely to be clicked next in order, that is still likely going to be an autodialer, even though you have a human being clicking a button under the new Florida statute. Really interesting stuff.
Huh, those are some big changes. And in terms of, if you have express written consent, then you're okay using what would be considered an autodialer. Is that a fair statement?
That is absolutely correct. So under the new Florida amendment, it's really interesting, okay? Before, under the same Florida statute, if you had an inquiry you had an established business relationship, you were just selling the customer something that they had already purchased from you, a little bit of a different EBR definition in the state than at the federal level, then you were safe to make those phone calls. But with the amendments that have taken place, just because a customer calls you and asks for information, just because you've sold a customer a product or a service before, that doesn't mean that you can contact that customer now using this new vague, broad definition of an auto dialer. Instead, Lisa, as you were pointing out, you have to have express written consent. Now, mercifully, the express written consent definition in the state law is very, very similar. In fact, I'm going to say it is the same for all intents and purposes with the CFR rules under the TCPA that the FCC has given us in terms of what express written consent is under the federal statute. So they're very, very, very similar. So if you're already capturing express written consent under the federal statute, that same consent will work under the Florida statute.
Okay. And in terms of what's considered, a Florida consumer, how does that work? Is it anybody with a Florida number? Is it somebody who's residing in Florida? How does that work?
It's a good question, right? The courts are going to have to solve that. Being in Florida is not actually required, technically speaking, under the statute. It's really interesting. So the statute adds a section that says there is a rebuttable presumption that if you are calling a area code for a Florida phone number, that you are calling a consumer who is subject to the act. But the act is not limited just to Florida consumers. Now, that might theoretically mean that if you call someone in California, they could sue you under the Florida statute because the Florida statute is not technically limited to people that live in Florida, but that's not going to work, right? The old concept of a state can only litigate or only regulate activity within the state is critical. There's kind of like a dormant commerce clause issue, but it is not something that I would expect to ever be enforced against somebody outside of Florida. For your purposes, person listening to this, not looking for like esoteric legal issues, if you're calling a Florida area code, you should assume you are calling a Florida consumer. If that Florida consumer happens to live in California and you know that and you're very, very confident of that, then you can go ahead and call that consumer because they're not going to have a right of action in Florida if they didn't receive a call in Florida or live in Florida at the time. But if they are living in Florida, or if they, let's say they have a Florida phone number, they do live in Florida, they're just out of, they're in California to visit Yosemite National Park for a week or something, and you call them, they're going to have a private right of action under this Florida enactment.
So tell us more about that private right of action. What does that entitle a person to do?
Yeah, so the telephone solicitation rules in Florida have been on the books now for a number of years, but you haven't really heard much about it because there was never a private right of action. And what a private right of action is the ability of a private consumer, just anybody, to file a lawsuit against you if you violate the law. So if under, this is 501.059 of the new Florida statute, if, for instance, you use this auto dialer, right, this very weird auto dialer definition, to contact a consumer for marketing purposes without express written consent, they can sue you for it. And just like under the TCPA, they can sue you for $500 per call, up to $1,500. It's exactly the same as the federal statute. And there's also an injunctive relief remedy available where they can go to court and say, dear court, make this guy stop suing me or stop calling me. And it's important to keep in mind that this is a state statute. So the TCPA, right, it's a federal statute. You're allowed to go to federal court because it's a federal statute. This is a state statute. Now, there might be opportunities to remove the claim to federal court, but by and large, these cases are going to be litigated in state court, not in federal court. So something to keep in mind. State courts, generally speaking, a little more unpredictable, right? They don't have the same resources that the federal court does in terms of having clerks and ample time to respond and prepare really well thought out rulings. So it's going to be a little bit of the wild, wild west. And callers should expect that they're going to lose some cases that they should have won, and maybe they'll win some cases that they should have lost because state court, you never really know what's going to happen.
Yeah, it'll be interesting to see. And another thing that'll be interesting to watch what plays out is, will this law be challenged? What do you think is going to happen, and how do you think that will play out?
I don't think there's any question that the amendments are unconstitutional. The amendments to .059, maybe they pass constitutional muster. To me, these things should still have to have strict scrutiny applied. But even under an intermediate scrutiny test, it's very likely to me that this Autodialer definition is too vague to be applied. It's going to be a due process issue, and there's a good likelihood that this thing does not leave other available channels for these kinds of marketers to communicate with customers. So that's a problem. But I got to tell you, 501603, which is the second set of amendments, it's just flat unconstitutional. And it's flat unconstitutional because the Supreme Court has told us in the AAPC decision that you cannot have a content-specific exemption in a restriction on speech. What that means is that the government cannot restrict speech based upon content. When they do that, they're violating the First Amendment. Now, when I grew up, I learned that the First Amendment protects our right to free speech in this country. The new Supreme Court disagrees, it turns out. They don't think you're entitled to free speech, but what you are entitled to is equal speech. And if you aren't allowed to speak, well, the other guy over there isn't allowed to speak either. And so when there's a Florida statute that says certain people, like marketers, aren't allowed to do things that other people, like folks soliciting charitable contributions, are allowed to do. Marketers can't do it, but charities can do it. That is not going to be allowed. And a marketer that challenges the statute should be successful under the AAPC decision. And to me, it's plainly unconstitutional. And it's funny because the Senate Commission report from the legislature looked at constitutional issues, and they failed to identify the fact that this is a content-specific restriction on speech, and that it's going to be it's just a stillborn statute, and they just missed it, which is very, very amusing to me. So this will, the 603 section, I really believe it's going to be challenged. I think it's going to go away.
Interesting. Well, and now Florida's just one of 50 states. Are there other states that have something similar in the works?
Well, so New York has a robocall bill that was being kicked around for a while and eventually died. The Florida bill is interesting because it passed with virtually no debate. Nobody knew about it. We picked it up and ran with it because I thought it was an interesting story. California has had a bill in the past, but there's no private right of action. It's definitely something that needs to be watched at the state level. I still expect to see federal action. I think most of the states are more or less just kind of taking a break and waiting to see if there's going to be federal action before they drive through any legislation of their own. Again, the Florida statute, it kind of came under cover of darkness. I mean, nobody was really expecting this. So, that being the case, it's tough to predict. No one saw the Florida bill coming, so maybe we won't see the Montana bill coming, or the Washington bill coming, or the Virginia bill coming, whatever it's going to be. But as of right now, California and New York have statutes on the books, but they don't have private rights of action. At least the California one doesn't, and the New York one, it's got a very, very narrow private right of action. And the Colorado bill was in the works for a while, targeting telemarketers. That one has stalled out as well. So it's tough to say, whether or not there might be some additional legislation coming down. There's of course statutes on the books in Texas and Connecticut and other places, South Carolina, that also purport to some degree to regulate marketing activity. So make sure know before you go, because there's a whole mess of statutes out there.
And as we always say, nothing in this little webinar should constitute legal advice, and we encourage organizations to always seek legal counsel. That being said, is there any kind of high-level suggestions that you might give to organizations that are dialing leads in Florida?
Well, obviously, you should be following TCPAWorld.com, right? I mean, we're breaking these things down in real time, giving you all the information that you need, totally free, no barriers around our content. Just check it out, it's there. But you really, as I tell people all the time, you have to have counsel anytime there's a change in the law, as there is right now. Anytime you're deploying a new outreach strategy, you just, you can't exercise without consulting a doctor, and you can't call people without consulting a lawyer, right? You really need to take this stuff extremely seriously, especially now that there's a private right of action. And remember, and I can't emphasize this enough, The plaintiff's bar in Florida is the most aggressive plaintiff's bar in the nation. And they got shut down under the TCPA by the 11th Circuit in a couple of big rulings. So these people are hungry. There's a bunch of lawyers out there that were feasting on steak, and for the last year and a half, because of some rulings at the 11th Circuit, they've been eating like hobos cans of warmed up beans, right? These people are starving, and they have this enactment that was just handed to them. They are going to go hog wild. There are going to be so many lawsuits under the statute. It's going to make the TCPA look like it was nothing. There will be, I predict there will be thousands of cases filed this year under this statute. So you've got to take this very seriously.
Absolutely. And, you know, coming from the software end, Convoso, as you know, makes outbound call center software. And one of the things that we encourage companies to do is make sure you're using an outbound dialer that can be modified for state level rules and you know, adjusted for valid call times, including some of these new Florida specific stuff. You know, with the Convoso dialer, we can allow for, you know, list level outreach strategies. So you can move, you know, you could move all of the Florida leads onto a separate Florida list and then treat that list separately. So could change the intervals or to how many times you call, as you said, only 3 times in 24 hours. You know, you can do rules based on cadences, on dispositions. So you've got different dispositions based on what would be on the Florida list. So we encourage you to make sure that your dialer can support your compliance for calling these leads into Florida. All right. Let's see, Eric, can we share the contact information if there's follow-up questions? I know you've got the TCPAWorld website. If they can bring that up. Also, Eric, I understand that there's going to be a compliance event happening in late July in Las Vegas.
Yeah, I mean, it's just like 2 weeks away, the Compliance Palooza. It's funny, Lisa, because I reached out to a bunch of folks today, and like 8 people were saying, Eric, this is the first time I've heard of this. How can that be? I have been talking about Compliance Palooza on TCPAWorld for 3 months now. We've had blasts, and so I start hand inviting people. I've had like a bunch of people telling me, oh, well, if I had known about this before, I would have gone. It's like, guys, pay attention to the website. Come on. So Compliance Palooza, it's in Las Vegas, Nevada. It's actually called the Great Vegas Compliance Palooza because it's great and it's in Vegas. July 22nd, 23rd, it's a 2-day event. It's going to be fantastic. Trust me, lots of surprises, lots of fun. CLE credit, like 11 or 12 hours of it. It's really cool. It's a really good opportunity to get out there, hang out with other lawyers, and have a good time while learning.
That's great. Eric, it's always a pleasure to talk to you, even when you have Cal Berkeley signs in your background. Always a pleasure to hear what you have to say. And thanks. We'll look forward to seeing you again.
Absolutely, and go Bears.
Go Trees.